Would you call the case, please? This is IT 9834I, the prosecutor, versus Mladen Naletilić, also known as Tuta, and Viko Martinovic, also known as Stella.
Merci beaucoup.
Thank you very much. First of all, I would like to say good afternoon to the people in the technical booth and to the interpreters, and to be sure that everybody can hear me.
Merci beaucoup.
Thank you. A good afternoon as well to the public who are watching these proceedings. The preliminary proceedings, which these are, these are the preliminary proceedings.
Plus précisément,
more specifically, this is the initial appearance of Mr. Naletilić, which is covered by Rule 62 of the Rules of Procedure and Evidence. I now turn to the prosecutor to ask for the appearances. Yes, Mr. President, the prosecution is represented by myself and by Frank Terrier, Douglas Stringer, and Mr. Vasily Poryovev. Thank you very much, Madam Prosecutor. I now turn to the defense. Would you introduce yourself, sir, and tell us what bar you are a member of and what your qualifications are for this tribunal as you presented them to the registrar?
Good afternoon to all, Your Honors. Let me introduce myself. I am Krešimir Krsnik, attorney from Zagreb. I am a member of the Croatian Bar Association in Zagreb. I would like to use this opportunity, Your Honors, to address this tribunal in my mother tongue, the Croatian, even though I speak the languages of this tribunal, and this is all I would like to do at this stage. Thank you.
Donc,
Mr. Kirsnik, am I saying it correctly, Mr. Kirsnik?
It's a little bit difficult to pronounce. It's Krsnik.
Kirsnik, yes, all right. You may be seated for the moment. Turning to the registrar. Has everything been prepared in respect of Mr. Kirsnik's qualifications? Yes, Your Honor, there are no problems in that respect. Thank you very much. I will now turn to Mr. Naletilić, who is appearing today for the first time further to an indictment which was established against him by the prosecutor of this tribunal. Mr. Naletilić, would you rise, please? And would you please answer the questions I'm going to ask you? Would you please state your name and your first name?
Mladen Naletilić.
Mladen Naletilić Tuta.
What is your date and place of birth?
It is the 1st December 1946.
oui. Et où est...
And where were you born?
Na Ciganskom brdu.
At Cigansko Brdo, municipality of Široki Brijeg in Bosnia and Herzegovina.
What is your profession and what was your residence before you came here?
Ja sam u zadnje vrijeme bio menadžer.
I was a manager and I lived at a hotel Esplanade in the last 5 or 6 months. And of lately I was in prison.
Are you married? Do you have any children?
Bio sam oženjen.
I was married and I do have children, that is correct.
Donc,
Today, Mr. Naletilić, this is your initial appearance before the tribunal. This is a formality. Of course, it is a substantive one where you must be present and conscious and aware with your attorney, because this is the time after your arrest when for the second time you are given the opportunity to familiarize yourself with all the charges that the Office of the Prosecutor has raised against you and which was confirmed by a judge until such time as evidence has been presented in an inter partes hearing. So that things be clear, Mr. Naletilić, I will first ask the registrar to read us the constituent texts, and these are the ones which provide you with a certain number of rights and which will then allow you to move to the most important formality of this appearance, that is, to ask you whether you wish to plead guilty or not guilty, and to know to which counts of the indictment you are pleading guilty or possibly not guilty. You may now be seated for the time that this is being read out, Mr. Naletilić. Nonetheless, I ask that you be very attentive to the reading of these texts, and your attorney as well, but your attorney is very familiar with them. Madam Registrar, would you please read the texts of Article 20 and 21 of the statute and Rule 62 of the Rules of Procedure and Evidence. Article 20 of the Statute of the Tribunal, commencement and conduct of trial proceedings. The trial chambers shall ensure that a trial is fair and expeditious, and that proceedings are conducted in accordance with the Rules of Procedure and Evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. The hearing shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21, Rights of the Accused. All persons shall be equal before the International Tribunal. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. The accused shall be presumed innocent until proved guilty according to the provisions of the present statute. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality: to be informed promptly and in detail, in a language which he understands, of the nature and charge and cause of the charge against him; to have adequate time and facilities for the preparation of his defense, and to communicate with counsel of his own choosing; to be tried without undue delay; to be tried in his presence, and to defend himself in person or through legal assistance of his own choosing; to be informed, if he does not have legal assistance, of this right; and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it; to examine or have examined the witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him; to have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal; not to be compelled to testify against himself or to confess guilt.
Article
Rule 62 of the Rules of Procedure and Evidence. Initial appearance of accused. Upon transfer of an accused to the seat of the tribunal, the President shall forthwith assign the case to a trial chamber. The accused shall be brought before that trial chamber or a judge thereof without delay, and shall be formally charged. The trial chamber or the judge shall satisfy itself, himself, or herself that the right of the accused to counsel is respected, read or have the indictment read to the accused in a language the accused speaks and understands, and satisfy itself, himself, or herself that the accused understands the indictment. Inform the accused that within 30 days of his initial appearance, he or she will be called upon to enter a plea of guilty or not guilty on each count, but that should the accused so request, he or she may immediately enter a plea of guilty or not guilty on one or more count. If the accused fails to enter a plea at the initial or any further appearance, enter a plea of not guilty on the accused's behalf. In case of a plea of not guilty, instruct the registrar to set a date for trial. In case of a plea of guilty, if before the trial chamber, act in accordance with Rule 62 bis, or if before a judge, refer a plea to the trial chamber so that it may act in accordance with Rule 62 bis. Instruct the registrar to set such other dates as appropriate.
Merci beaucoup.
Thank you very much, Madam Registrar. Let me now turn to Mr. Kirsnich. Mr. Kirsnick. Has the accused received a copy of the indictment in his language? And does he understand its contents?
Yes, Your Honor. My client has received a copy of the indictment and understood it.
Excusez-moi, Maître Krasnik.
Excuse me, Mr. Kirsnick, I was not listening to the right channel. Would you please repeat that? I've made a mistake here.
Yes, my client has received a copy of the indictment and has understood it.
Monsieur Naletilić.
Mr. Naletilić, would you rise, please?
Monsieur Naletilić.
Mr. Naletilić, have you received the indictment in your own language?
Yes.
I received it.
Avez-vous
Did you understand the contents of the indictment?
Da, vrlo dobro.
Yes, very well.
êtes-vous
Are you prepared today to tell us whether you plead guilty or not guilty to each of the counts?
Oui, je vois que Maître Krasnik.
I see that Mr. Kirsnick wants to speak before his client answers. Please, Mr. Kirsnick, proceed.
Thank you, Your Honor. Before my client makes his plea on the indictment, I would like to point out a very serious problem, which is the condition of health of my client. My client has a serious heart condition and has been in intensive therapy for the last 6 months. He had 4 surgeries, 4 operations on his coronary arteries, and an expert team from Amsterdam was sent to Zagreb and conducted 2 examinations. After the second examination, they established that he was only able to be transported, but nothing else. The doctors of the University Hospital in Zagreb have warned both myself and the Office of the Prosecutor of a very serious risk that Mr. Naletilić is running in attending this trial, and the increased stress that he may be exposed to may lead to fatal consequences. So for these reasons, my opinion is that, first of all, we need to have an expert examination both the medical and psychological experts should be involved, and only upon their finding we could go ahead with the proceeding. Believe that this tribunal should abide by the highest standards of the international law, and we hope that you will agree that Mr. Naletilić should be first examined before we proceed, and if the trial chamber does not agree to this proposal of ours, we will submit it in writing following this session.
Excuse me, Mr. Kirsnick. I'm going to ask Mr. Naletilić to be seated for the time being. You may be seated, Mr. Naletilić. What is your request now, Mr. Kirsnick? This is the initial appearance. The initial appearance is a formality, as you know, during which the accused must plead guilty or not guilty to each of the counts. This is not the trial. And as you have heard, your client said that he received the indictment in his own language, that he understood its contents. Therefore, right now, he need merely answer whether he pleads guilty or not guilty. What is it that you're requesting now?
Your Honors, very simple. It's very simple. The position of the defense is this. My client's health is at such risk that at any moment the most serious and grave consequences may ensue. And I need to point this out both for his sake and for my own sake, Your Honors.
I will give the floor to the prosecutor, but I would like to tell you that the trial is not going to begin today. We're not speaking about beginning the trial.
Yes, I understood this. I understood this very well. However, the position of the defense is that we cannot even start the proceedings before we had an expert report. Whether he is capable of attending these proceedings at all, and only experts can determine this, regardless of the fact that this is a formality. As far as the defense is concerned, the proceedings are beginning now, and we say that we have to determine whether he is able to attend, because it may lead to the fatal consequences.
Madame le procureur.
Madam Prosecutor, what is your opinion in respect of this request? Yes, Your Honor. I would say that the initial appearance has already begun. We're just about complete with it. All we need is a response from the accused who tells us whether he is pleading guilty or not, because he's familiar with the indictment, with the charges. The defense is now telling you, my client cannot answer because his medical condition doesn't allow him to do so. Mr. President, we can't follow this any further. Insofar as we all agree that if the defense is asking for an evaluation, we have nothing against that. There already have been 2 or 3 or 4. Well, we'll have one more. All right, we agree, no problem. But that the state that we should say right now that the accused tutor cannot even answer without endangering his health. There, I just cannot understand. Your Honor, I feel that this hearing, this initial appearance, is one which we should be able to complete, and it can be completed very easily. It can just simply tell us, either or it doesn't say anything at all, because in the rules it says that if he doesn't plead one way or the other, the third solution will take place, which means that he simply does not want to express himself orally in that respect. There you are. The prosecution opposes the request stating that the evaluation can be done tomorrow. Thank you, Madam Prosecutor. Mr. Kirsnick, I cannot do your work. The presiding judge cannot do your work. But you heard Rule 62 being read out, and when I started, by asking what is your motion, you had to tell us. You just can't give us an opinion simply. I'll give you the floor, and I cannot tell you that you must do this or that. I am only asking what your motion is. What is your request? I give you the floor, Mr. Kirsnick.
Thank you. My request is very clear, and I do not agree with my learned colleague, the prosecutor, at all. It is not a question of my client pleading yes or no. My request has been very clearly stated. The position of the defense is that I want the expertise to determine whether my client is able to be present in these proceedings, and this is what we have said at the very beginning. Before we start the proceeding, we need to resolve this. Madam Prosecutor, we can just conduct this expertise, and the experts will tell us very clearly that he is not able to be present at the trial, and that his presence there would put him at risk to have the most fatal consequences. So before we start the proceedings, I am opening a very serious issues. This may happen right now. What happens if he suffers a seizure now? And what would I have done had I not warned the trial chamber of this?
Mr. Kirsnick, you are an attorney. Is that correct? You're not a physician. The trial chamber knows, and we have received an evaluation from the doctors stating that they concluded that the patient, Mladen Naletilić, is currently capable from his mental point of view to understand. We're talking about understanding, only understanding what is happening. And he is mentally suitable in order to understand the charges and the proceedings that have been engaged against him and to contribute to his own defense. The problem now is is only knowing whether he is able to understand. The doctors have said yes, and that's why we're here. I'm going to ask you, just for a moment, I want to confer with my colleagues, and then the chamber will take a decision.
Chambre
The trial chamber considers that the request of the defense that we postpone the time for pleading guilty or not guilty, I believe that's the correct interpretation of the request, pursuant to Rule 62 of the Rules of Procedure and Evidence, if the accused does not plead one way or the other at the initial appearance or at a subsequent appearance, takes note in his name of a plea of not guilty. But the chamber considers that he must be very well informed of the indictment. And for that reason, the chamber orders that the indictment be read out The accused, however, can postpone his plea of guilty or not guilty to another date. Madam Registrar, I'm now going to ask you to read the indictment completely.
Your Honor, the defense is familiarized with the indictment, and it is not necessary to read it out. And the client is also familiar with it, so we waive the right for the indictment to be read.
Non, mais comme vous savez,
As you know, there is also a public dimension in our hearings. There is a public present here, and that public wants to know what the charges are. For that reason, the trial chamber orders that the entire indictment be read out. Thank you, in any case, for calling my attention to what you just said. Madam Registrar. Case IT 9834I, the prosecutor versus Mladen, Naletilić, also known as Tuta, and Vinko Martinovic, also known as Stella. Indictment. The prosecutor of the International Criminal Tribunal for the former Yugoslavia, pursuant to her authority under Article 18 of the Statute of the International Criminal Tribunal for the former Yugoslavia, hereinafter the Statute of the Tribunal, charges Mladen Naletilić, a.k.a. Tuta, and Vinko Martinovic, also known as Stella, with crimes against humanity, grave breaches of the Geneva Conventions, and violations of the laws or customs of war. Background. On 25 June 1991, Croatia declared its independence, which was suspended until 8 October 1991. The Republic of Croatia was recognized by the European Community on 15 January 1992, and it was admitted as a member state of the United Nations on 22 May 1992. Bosnia and Herzegovina declared its independence on 3 March 1992. The Republic of Bosnia and Herzegovina was recognized by the European Community on 6 April 1992 and by the Republic of Croatia on 7 April 1992. The Republic of Bosnia and Herzegovina was admitted as a member state of the United Nations on 22 May 1992. The Croatian Community of Herzegovina, HCHB, proclaimed its existence on 18 November 1991 and claimed to be a separate or distinct, quote, political, cultural, economic, and territorial whole, end of quote, in the territory of Bosnia and Herzegovina. Its purposes included, inter alia, the establishment of closer ties with the Republic of Croatia. These aspirations, which were supported by the Republic of Croatia, were evidenced by the HCHB's use of the Croatian currency and the Croatian language and the granting of the Republic of Croatia Croatian citizenship to Bosnian Croats. The Constitutional Court of the Republic of Bosnia and Herzegovina declared the HCHB illegal on 14 September 1992. Neither the self-proclaimed HCHB nor the later self-proclaimed Croatian Republic of Herzegovina, HRHB, were ever internationally recognized. Article 3 of the HCHB proclamation of 18 November 1991 designated Mostar as the capital of this community.
This designation of Mostar as capital of the self-proclaimed Croat community was reaffirmed by the decree issued by the president of HZHB on 8 April 1992, setting up the Croatian Defense Council, hereinafter referred as HVO, as the supreme executive, administrative, and defense body of Herceg-Bosna, with its headquarters in Mostar, and the decree by such President on 28 August 1993, by which the HZHB declared itself the HRHB. The population of the municipality of Mostar prior to the beginning of the conflict, 1991 official census, was composed of 126,628 inhabitants, of which 43,856 or 34.6% were Muslims, 43,037 or 33.9% were Croats, and 23,846, 18.8% were Serbs. 12,768, 9.9% were Yugoslavs, and 3,121 or 2.4% were others. The city of Mostar is the historical capital and largest city in Herzegovina. The territory of the municipality of Mostar includes, among others, the following districts and villages: Raštani, Bijelopolje, Vojno, Potoci, Rudnik, Ilići, Đikovina, Panjevina, Rodoč, Podhum, Zahum, and Blagaj. At all times during the relevant period, the Army of the Republic of Croatia, HV, backed and supported the HVO and deployed its own units in Mostar and other municipalities of Bosnia and Herzegovina. Among the units that were acting in connection with the authorities of the Republic of Croatia and participated in joint actions with units of the HV was the Kažnjenička Bojna, Convicts Battalion, also known as the Punishment Battalion, Tutićeva Brigade, Tutići or Tuta's Men, hereinafter referred to as KB, under the command of Mladen Naletilić. As early as October 1992, the HVO launched an attack against the Bosnian Muslim population of the municipality of Prozor. Subsequently, the HV and HVO participated in an armed conflict with the armed forces of the government of Bosnia and Herzegovina, ABIH, until February 1994. In April 1993, the HVO launched a series of attacks against the Bosnian Muslim civilian population, such as the attack of Ahmići on 16 April and others in central Bosnia. At the same time, on 17 April 1993, forces of the HV and HVO, including the KB, attacked the villages of Sovići and Doljani in municipality of Jablanica under the overall command of Mladen Naletilić and carried out the forcible transfer of the Bosnian Muslim population and destruction of their properties. Beginning simultaneously in April 1993, in the Herzegovinian municipalities of Stolac, Čapljina, and Mostar, the HVO carried out the arrest of prominent Bosnian Muslims and imposed different measures of persecution against the Bosnian Muslim population, such as dismissals from work positions and public service, discrimination in the delivery of humanitarian aid, attacks against Bosnian Muslim houses and properties, and imposition of Croat language and education. On 9 May 1993, the HV and HVO, including the KB, launched a large military offensive against the Bosnian Muslim population of Mostar and the positions of the ABIH in the city, provoking the start of an armed conflict with the ABIH in the municipality of Mostar. Subsequently, the Bosnian Muslim population was the target of a broad campaign of violence in the areas of Mostar occupied by the HV and HVO, lasting at least until the ceasefire and peace agreements of February and March 1994. Across the confrontation line, the ABIH-held section of the city was under siege by the HV and HVO forces, who were shelling intensely the area and preventing the arrival of humanitarian aid and basic supplies. Mladen Naletilić, as commander of the KB, and Vinko Martinović, as commander of the Mrmak or Vinko Škrobo subunit of the KB, were leading perpetrators of this campaign against the Bosnian Muslim population. The goal of this campaign by the HV and HVO forces, commonly referred to as ethnic cleansing, was to gain control of the municipalities of Mostar, Jablanica, and others in Bosnia and Herzegovina, and to force the Bosnian Muslim population to leave these territories or to substantially reduce and subjugate this population. The means used for this purpose included killings, beatings, torture, evictions, destruction of cultural and religious heritage, looting, deprivation of basic civil and human rights, and mass expulsions, detentions, and imprisonments, all of them executed following a systematic pattern of ethnic discrimination. As a result of this campaign, tens of thousands of Bosnian Muslims abandoned Mostar, Jablanica, and other municipalities in Bosnia and Herzegovina. The traditional ethnic diversity of these municipalities was virtually eliminated, and an ethnically homogeneous society and institutions were imposed in these areas. The accused. Mladen Naletilić, also known as Tuta, son of Mate and Slavka, was born on 1 December 1946 in Lištica, Široki Brijeg, in the municipality of Široki Brijeg, Bosnia and Herzegovina. Mladen Naletilić is by birth a Bosnian Croat who later acquired the citizenship of the Republic of Croatia, which he maintains to date. Mladen Naletilić graduated from elementary school. Mladen Naletilić left the Socialist Federal Republic of Yugoslavia in the late 60s or early 70s and remained abroad until his return to his country of origin in 1990.
Madam Register, would you skip paragraph 13, because that refers only to Mr. Martinović, and move to paragraph 14?
Autorité du supérieur hiérarchique.
Superior authority. At all times material to this indictment, Mladen Naletilić was the commander of the KB, a special unit founded by him on or about June 1991. The KB was composed of approximately 200 to 300 soldiers grouped in several subunits called ATG or ATJ, Anti-Terrorist Group or Unit, with bases in the municipalities of Mostar, Lištica, Široki Brijeg, and Ljubuški. The main tasks of the KB were combat missions on the front line, expulsions and attacks against Bosnian Muslim civilians in the territories under the HVO and HVO occupation. The KB acted as part of or in coordination with the HVO and HV. Mladen Naletilić exercised his control in military matters in a manner consistent with the exercise of superior authority, including the development of the organizational structure within the KB. He was involved in the management and control of the finances of the KB. Mladen Naletilić was also in charge of dispersing the salaries of members of the KB, deciding on logistical and tactical matters, ensuring the combat readiness of his troops, planning the preparation and implementation of military operations performed either by the KB alone or in coordination with other HVO or HV units under the general command of both armies, and coordinating with high-ranking officers of the HCSHB, the HRHB, and the Republic of Croatia. Mladen Naletilić exercised his authority over the members of the KB in a direct manner by meeting with his direct subordinates and KB subcommanders on virtually a daily basis, interacting with the rank-and-file soldiers frequently, visiting the different bases of the KB, and acting as a field commander for certain military actions. Vinko Martinović was a commander in the HOS, Croatian Defense Forces militia, in Mostar in 1992 and later joined the KB. At all times material to this indictment, Vinko Martinović was the commander of the KB subunit ATG Mermak, later named Vinko Škrobo, and a subordinate to Mladen Naletilić. In a manner consistent with the exercise of superior authority, Vinko Martinović participated in military operations under the command of the KB and in coordination with other HVO and HV units under the general command of both armies. At all times material to this indictment in the city of Mostar, Vinko Martinović was in command of a section of the front line in the Boulevard Street, where the ATG Mermak, later named Vinko Škrobo, was deployed under his command, and the base and facilities of this unit in the Kalemova Street. General allegations. At all times relevant to this indictment, a state of international armed conflict and partial occupation existed on the territory of the Republic of Bosnia and Herzegovina. All acts or omissions set forth as grave breaches of the Geneva Conventions of 1949, hereinafter grave breaches, recognized by Article 2 of the Statute of the Tribunal, occurred during that international armed conflict and partial occupation. All of the victims to whom the charges refer, whether they were civilians or prisoners of war, were, at all relevant times, persons protected by the Geneva Conventions of 1949. In each paragraph charging crimes against humanity, the alleged acts or omissions were part of a widespread, large-scale, or systematic attack directed against the Bosnian Muslim population. The accused in this indictment were required to abide by the regulations of the laws or customs of war governing the conduct of war, including the Geneva Conventions of 1949. Mladen Naletilić and Vinko Martinović are individually responsible for the crimes with which they are charged in this indictment pursuant to Article 7.1 of the Statute of the Tribunal. Individual criminal responsibility involves planning, instigating, ordering, committing, or otherwise aiding and abetting in the planning, preparation, or execution of the acts or omissions set forth below. Mladen Naletilić and Vinko Martinović are also, or alternatively, responsible as superiors for the acts of their subordinates pursuant to Article 7.3 of the Statute of the Tribunal. A superior is responsible for the acts of his subordinates if the superior knew or had reason to know that his subordinate was about to commit such acts or had done so, and the superior failed to take the necessary and reasonable measures to prevent such further acts or to punish the perpetrators thereof.
Charges count 1, persecutions. On 17 April 1993, in the municipality of Naletilić, the KB, along with other HV and HVO units, attacked the villages of Sovici and Doljani and subsequently carried out a forcible transfer of the Bosnian Muslim population, destruction of their properties, and destruction of the Mosque of Sovici. Mladen Naletilić was the overall commander of this attack and ordered his subordinates to destroy the Bosnian Muslim properties and the Mosque of Sovici, to arrest all of the Bosnian Muslim adult males, and to expel and forcibly transfer Bosnian Muslim civilians to the territory under ABIH control. In the municipality of Mostar, the forcible transfer and imprisonment of Bosnian Muslim civilians started simultaneously with the HV and HVO attack of 9 May 1993 and continued until at least January 1994. However, there were two large waves of forcible transfers and imprisonment. One in the days following the 9th of May 1993 attack, and a second during the first days of July 1993. Once the KB and other HVO units had identified persons of Muslim ethnic background, they arrested them, evicted them, plundered their homes, and forcibly transferred them to detention centers under HVO authority or across the confrontation lines to the territories under ABIH control. Between April 1993 and until at least January 1994, thousands of Bosnian Muslim civilians were interned in the detention centers under HVO authority in the area of Mostar and neighboring municipalities. beatings, torture, killings were common and persistent in these detention facilities. The Heliodrome compound, located in Rodac, municipality of Mostar, was the main detention center in the area. Bosnian Muslim civilians and prisoners of war arrested under the command of Mladen Naletilić and Vinko Martinović were interned in the Heliodrome. Members of the KB mistreated and tortured Bosnian Muslim detainees at the Heliodrome. Furthermore, throughout the relevant period, subordinates to Mladen Naletilić and Vinko Martinović regularly took detainees from the Heliodrome to the front lines to force them to perform labor and use them as human shields. Throughout this period, Mladen Naletilić visited on numerous occasions the Heliodrome camp and had knowledge of the existence of Bosnian Muslim civilian prisoners and the inhumane conditions of this camp and the mistreatment of detainees. Mladen Naletilić was in contact with the commanders of the Heliodrome, had access to the main facilities of the compound, and exerted command over the KB troops based in the compound. In the Kalanova Street of the city of Mostar, the KB maintained the base of the subunit called ATG Mirmak, later named Vinko Srobko, under the command of Vinko Martinović. Bosnian Muslim detainees were kept in this base, which was used as a center for the attacks against Bosnian Muslim civilians, particularly evictions, looting, expulsions across the front lines, and use of detainees for forced labor and human shield purposes. Mladen Naletilić regularly visited these premises to meet Vinko Martinović and other KB members. Mladen Naletilić knew the existence of detention centers in Mostar and neighboring municipalities other than the Heliodrome, in which Bosnian Muslim civilians were interned and mistreated. In particular, Mladen Naletilić had knowledge of the detention centers located in the municipality of Listica, Široki Brijeg, such as the primary school of Dobrokovići, the MUP police station, and the bases of the KB in Listica, Široki Brijeg, Ljubuški, and Mostar, where Bosnian Muslims were also detained. Bosnian Muslim detainees of the primary school of Dobrokovići were forced to work in Mladen Naletilić's private estate. Under the command of Mladen Naletilić and Vinko Martinović, the KB forcibly transferred Bosnian Muslim civilians to the confrontation line in the municipality of Mostar and forced them to cross the confrontation line towards the ABIH side. Mladen Naletilić and Vinko Martinović gave orders to expel the Bosnian Muslim population and loot and destroy their houses and properties. Throughout the period, Mladen Naletilić and Vinko Martinović repeatedly tortured Bosnian Muslim detainees, ordered their subordinates to torture Bosnian Muslims, and by their example instigated their subordinates to commit and carry out torture. Severe physical and mental suffering was intentionally inflicted on Bosnian Muslims for the following purposes: to obtain from them information, to punish them, to retaliate due to adverse developments in the front lines, to intimidate them, or based on their ethnicity or religion. Between about April 1993 and at least January 1994, Mladen Naletilić, as commander of the KB, and Vinko Martinović, as commander of the Mirmak or Vinko Srobo subunit of the KB, together with other leaders, agents, and members of the HV and HVO, planned, instigated, ordered, or committed, or aided and abetted the planning, preparation, or execution of a crime against humanity through the widespread and systematic persecutions of Bosnian Muslim civilians on political, racial, ethnic, or religious grounds throughout the territory claimed to belong to the HCHB and HRHB by the following means, including as applicable the acts and conduct described in counts 2 through 22 below. A. Unlawfully confining, detaining, forcibly transferring, and deporting Bosnian Muslim civilians, including as described in paragraphs 53 and 54. B. Subjecting Bosnian Muslims to torture and inhumane acts, inhuman and cruel treatment, murdering and willfully killing them, willfully causing them great suffering, using them to perform unlawful and forced labor, including on the confrontation lines in Mostar, and using them as human shields, which in some instances resulted in their death, including as described in paragraphs 35 to 52. C. Destroying and wantonly devastating Muslim and Muslim dwellings and buildings, including as described in paragraphs 55, 56, and 58. And D. Plundering public and private property of Bosnian Muslims, including as described in paragraph 57. By these acts and omissions, Mladen, Naletilić, and Vinko Martinović committed, count 1, persecutions on political, racial, and religious grounds, a crime against humanity as recognized by Articles 5H, 7.1, and 7.3 of the Statute of the Tribunal.
Chef 2 à 8.
Counts 2 to 8. Unlawful labor and human shields as is human treatment and willful killing. Between about April 1993 and at least through January 1994, Mladen, Naletilić, Vinko Martinović, and their subordinates forced Bosnian Muslim detainees from the various detention centers under the authority of the HVO to perform labor in military operations and to be used as human shields on the Boulevard and Šantićeva streets, Raštani, Stotina, and other locations along the front line in the municipality of Mostar. Following the HV and HVO attack on the city of Mostar on 9 May 1993, the confrontation line with the ABIH was settled along the Boulevard and Šantićeva streets. From May 1993 to February 1994, the KB was engaged in fighting along the Boulevard and Šantićeva streets and had control over particular sections of this confrontation line. This confrontation line was both the scene of intense small arms fire and artillery exchanges between the opposing factions, and it was the main site to which Bosnian Muslim prisoners were taken to perform forced labor and to be used as human shields. From May 1993 through at least January 1994, on a regular basis, detainees were taken from the Heliodrome camp and other detention centers to the bases of the KB in the city of Mostar for eventual transfer to the confrontation lines. The detainees were forced, at great risk to their lives, to perform various dangerous military support tasks benefiting the HV and HVO, including digging trenches, building defenses with sandbags, carrying wounded or killed HV or HVO soldiers, carrying ammunition and explosives across the confrontation line, and placing them in front of the ABIH positions. These tasks were often performed by the detainees under conditions which exposed them directly to hostile fire and thereby served the purpose of protecting HVO soldiers. Consequently, the detainees were turned into human shields. On other occasions, the KB used detainees exclusively to protect the KB and other HV and HVO soldiers from hostile fire or to attract hostile fire on the detainees in order to ascertain the ABIH positions. The circumstances of intense fire exchange and the direct exposure of the detainees and prisoners to such fire, adding to the short distance between the two warring factions, presented a high likelihood of death or serious injury to the detainees and prisoners. Mladen, Naletilić, and Vinko Martinović were aware of these circumstances. The knowing exposure of the Bosnian Muslim detainees to these conditions resulted in their inhuman treatment and, in some instances, injuries and death. From May 1993 to January 1994, Mladen Naletilić repeatedly visited the Heliodrome camp and the bases of the KB in the city of Mostar, where he met his subordinates and detainees. Mladen Naletilić had knowledge of the use of prisoners and detainees for forced labor and human shields, and was also aware of the resulting injuries and deaths.
You can move to paragraph 43, since the others refer only to Mr. Martinović. Resume with paragraph 43.
Le 20...
Paragraph Paragraph 43. On 23 September 1993, Mladen Naletilić commanded an attack by the KB on the village of Rashtani, municipality of Mostar. In the course of the attack, Bosnian Muslim detainees taken from the heliodrome were forced to walk in front of the attacking forces and to enter and search enemy positions. The detainees were forced to perform these tasks exposed to the ongoing exchange of fire at great risk to their lives. Throughout this period, Mladen Naletilić, Vinko Martinović, and their subordinates also forced Bosnian Muslim detainees to perform labor in locations other than the front lines. The Bosnian Muslim detainees were forced, inter alia, to engage and participate in the following works: building, maintenance, and reparation works in private properties of the members and commanders of the KB, digging trenches, building defenses in the positions of the KB or other HV and HVO forces, and assisting the KB members in the process of looting houses and properties of Bosnian Muslims. By these acts and omissions, Mladen Naletilić and Vinko Martinović committed count 2, inhumane acts, a crime against humanity as recognized by Articles 5I, 7.1, and 7.3 of the Statute of the Tribunal. Count 3, inhuman treatment, a grave breach of the Geneva Conventions of 1949 as recognized by Articles 2B, 7.1, and 7.3 of the Statute of the Tribunal. Count 4, cruel treatment, a violation of the laws or customs of war under Statute Articles 3 as recognized by Article 3.1a of the Geneva Conventions and Statute Articles 7.1 and 7.3. Count 5, unlawful labor, a violation of the laws or customs of war under Statute Article 3 as recognized by Article 51 of Geneva Convention 4 and Article 49 and 50 of Geneva Convention 3 and Statute Article 7.1 and 7.3. Count 6, murder, a crime against humanity as recognized by Articles 5A, 7.1, and 7.3 of the Statute of the Tribunal. Count 7, willful killing, a grave breach of the Geneva Conventions of 1949, as recognized by Articles 2A, 7.1, and 7.3 of the Statute of the Tribunal. Count 8, murder, a violation of the laws or customs of war under Statute Article 3, or as recognized by Article 3.1a of the Geneva Conventions and Statute Article 7.1 and 7.3.
Chef
Counts 9 to 12, torture and willfully causing great suffering. Beginning in May 1993, and at least through January 1994, Mladen Naletilić, Vinko Martinović, and their subordinates tortured or willfully caused great suffering to Bosnian Muslim civilians and prisoners of war captured by the KB or detained under the authority of the HVO. Severe physical and mental suffering was intentionally inflicted on Bosnian Muslim detainees for the following purposes: to obtain from them information, to punish them, to retaliate due to adverse developments in the front lines, or to intimidate them based on their ethnicity or religion. Throughout this period, Mladen Naletilić and Vinko Martinović repeatedly committed, aided and abetted torture, willfully caused great suffering, and by their example, instigated and encouraged their subordinates to torture or cause great suffering on Bosnian Muslim detainees. Mladen Naletilić committed and instigated the commission of torture or the infliction of great suffering on Bosnian Muslim detainees on the 20th of April 1993, following the attack against the Bosnian Muslim population of Sovici and Doljani, carried out by HV and HVO forces under his overall command. In the context of the preparations of the HV and HVO attack on Mostar on 7 May 1993, unidentified members of the KB arrested in Mostar witness B, whom at the time was a prominent figure within the Bosnian Muslim community, and took him to a base of the KB in Lišica, Široki Brijeg. At that time, Mladen Naletilić and his subordinates tortured witness B, causing severe injuries. Following the HV and HVO attack on Mostar on 10 May 1993, Mladen Naletilić physically assaulted witness M, who was a prisoner of war captured in Mostar by Mladen Naletilić's subordinates. Madam Registrar, you could move to paragraph 49, rather to 50. Paragraph 50. Throughout this period, the beatings and torture of Bosnian Muslim civilians and prisoners of war became a common practice of the members of the KB. Beatings and torture of Bosnian Muslim civilians and prisoners of war were committed by a large number of members of the KB, including commanders. These beatings and tortures were committed at different bases of the KB in Mostar, Liščica, Široki Brijeg, and Ljubiški. Beatings and torture were also inflicted at other detention centers and camps under the authority of the HVO, such as the Ljubuški prison and the Heliodrome camp. Beatings and tortures were additionally inflicted at several other locations following the capture of prisoners. Mladen Naletilić and Vinko Martinović knew or had reason to know that their subordinates were about to commit such acts or had done so, and they failed to take the necessary and reasonable measures to prevent such further acts or to punish the perpetrators thereof. By these acts and omissions, Mladen Naletilić and Vinko Martinović committed, count 9, torture, a crime against humanity, under Articles 5F, 7.1, and 7.3 of the Statute of the Tribunal. Count 10, torture, a grave breach of the Geneva Conventions of 1949, under Statute Article 2B and 7.1 and 7.3 of the Statute of the Tribunal. Count 11, cruel treatment, a violation of the laws or customs of war under Statute Article 3 as recognized by Articles 3.1a of the Geneva Conventions and Article 7.1 and 7.3 of the Statute of the Tribunal. Count 12, willfully causing great suffering or serious injury to body or health, a grave breach of the Geneva Conventions of 1949, under Articles 2C, 7.1, and 7.3 of the Statute of the Tribunal. Madam Registrar, please move down to paragraph 53. That is count 18. The others have to do only with Mr. Martinović.
Count 18, forcible transfer. On about 17 April 1993, following the plans and under the overall command of Mladen Naletilić, the KB, along with the other HV and HVO forces, attacked the villages of Sovići and Doljani in the municipality of Jablanica. After the capture of Sovići, the attacking forces forcibly interned several hundreds of Bosnian Muslim civilians in the local primary school on 18 and 19 April 1993. On the following days, the forces under the command of Mladen Naletilić confined the whole of the Bosnian Muslim civilian population of Sovići, around 450 women, children, and elderly, to the hamlet of Junuzovići, and forcibly transferred them subsequently to the territory of Gornji Vakuf under the control of the ABIH. In the municipality of Mostar, Mladen Naletilić and Vinko Martinović were responsible for and ordered the forcible transfer of Bosnian Muslim civilians that started on 9 May 1993 and continued until at least January 1994. The KB members under his command were prominent in the eviction, arrest, and forcible transfers of Bosnian Muslim civilians throughout the relevant period, and particularly during the two large waves of forcible transfers that took place in May and July 1993. Once the KB and other HVO units had identified persons of Muslim ethnic background, they arrested them, evicted them, plundered their homes, and forcibly transferred them across the confrontation lines to the territories under ABIH command. The ABIH held a section of the city which was under siege by the HV and HVO forces, who were shelling intensely the area and preventing the arrival of humanitarian aid and basic supplies. Mladen Naletilić and Vinko Martinović commanded operations for this purpose and gave orders to their subordinates to proceed with the forcible transfers. By these acts or omissions, Mladen Naletilić and Vinko Martinović committed count 18, unlawful transfer of a civilian a grave breach of the Geneva Conventions of 1949, as are recognized by Articles 2G, 7.1, and 7.3 of the Statute of the Tribunal.
F 19.
Counts 19 to 22, destruction and plunder of property. Following the capture of Sovici and Doliani on 17 April 1993, Mladen Naletilić ordered the destruction of all the Bosnian Muslim houses in the area. The systematic destruction of the Bosnian Muslim houses was carried out by the forces under the authority of Mladen Naletilić, who at the relevant time was in command over the area occupied by the HV and HVO forces. Following the capture of Sovici and Doliani on 17 April 1993, Mladen Naletilić ordered the destruction of the Mosque of Sovici. The mosque was destroyed by the forces under the authority of Mladen Naletilić, who at the relevant time was in command over the area occupied by the HV and HVO forces. Following the HV and HVO attack on Mostar of 9 May 1993, and in the context of the subsequent campaign of persecutions against the Bosnian Muslim population, the units under the command of Mladen Naletilić and Vinko Martinović plundered systematically the Bosnian Muslim houses and properties. Following the capture of the village of Rashtani, municipality of Mostar, on 23 September 1993, the forces under the command of Mladen Naletilić destroyed the Bosnian Muslim houses of the village. By these acts and omissions, Mladen Naletilić and Vinko Martinović committed, count 19, extensive destruction of property, a grave breach of the Geneva Conventions recognized by Articles 2D, 7.1, and 7.3 of the Statute of the Tribunal. Count 20, wanton destruction not justified by military necessity, a violation of the laws or customs of war, as recognized by Articles 3B, 7.1, and 7.3 of the Statute of the Tribunal. Count 21, plunder of public and private property, a violation of the laws or customs of war, as recognized by Articles 3E, 7.1, and 7.3 of the Statute of the Tribunal. Count 22, seizure, destruction, or willful damage done to institutions dedicated to religion, a violation of the laws or customs of war, as recognized by Articles 3D, 7.1, and 7.3 of the Statute of the Tribunal. The prosecutor, Louise Arber, dated this 18th day of December 1998, The Hague, the Netherlands.
Je me reprends.
I repeat, dated this 18th day of December 1998, The Hague, the Netherlands.
Merci beaucoup.
Thank you very much, Madam Registrar. This was the time to ask Mr. Naletilić whether he was pleading guilty or not, but the defense has told us that it wishes that moment to be postponed. I think that refers to Rule 62, little 3, within 30 days of the initial appearance. And therefore, the trial chamber will postpone the time for pleading guilty or not guilty. Excuse me, I think that Mr. Naletilić wants to say something. Mr. Kirsnik? Could you tell us what it is that your client wants to say?
Yeah. Now, my client.
Yes, my client would like to plea, to make a plea, and this is what he just told me.
Very well. So that things be clear. Mr. Kirsnik, is your client in a position to plead guilty or not guilty today?
Your Honor, this is his decision. He obviously feels capable of pleading about his guilt today.
Let me turn to Mr. Naletilić. Do you feel yourself capable of pleading guilty or not guilty today?
Yes.
Très bien.
Very well. We're going to do that immediately. We are going to have to go back to the indictment, and it's going to take a little longer because we have to read each of the counts in order to know whether Mr. Naletilić is going to plead guilty or not. Because he cannot simply state in general terms that he pleads guilty or not. And we're doing all of this, well, rather we had done this with the idea of postponing the plea of guilty or not guilty, but now that Mr. Naletilić has changed his mind, and you have the right to do so today, as you have the right to do 30 days from now. Madam Registrar, since we have already read the indictment, as we have read the indictment, we are going to read only the counts. That is, Madam Registrar, please reread the parts of the indictment. Page 10. Please read count 1. Count 1, persecutions on political, racial, or religious grounds, a crime against humanity, as recognized by Articles 5H, 7.1, and 7.3 of the Statute of the Tribunal. Mr. Naletilić, do you plead guilty or not guilty to that count?
First of all, Your Honors, I would like to thank my attorney, Krasnik, as well as Madam Carla Di Ponte.
I must interrupt you. I am not receiving the interpretation at this point.
Maintenant, oui. Maintenant, oui.
Now I'm getting it. But I wasn't a minute ago. Excuse me, Mr. Naletilić.
No problem, no problem. So I would like to thank my attorney for his concern about my health. I would like to thank the prosecutor, Carla Del Ponte, that she trusts me, obviously, that I can endure this, including the plea today. And as far as the my children, the KB unit, and the members of my...
Excuse me for interrupting. Excuse me for interrupting you. Excuse me. Mr. Naletilić.
Excusez-moi.
Excuse me. At the end of this hearing, you will be able to speak. Now, I have simply asked you whether you plead guilty or not, and you must answer only I plead guilty or I plead not guilty. If it is a crime to defend one's own country, then I am guilty. If not, if it is not, then I'm not guilty. But let me tell you just one thing. In respect of everything, I ask of this tribunal to take a lie detector. Excuse me, Mr. Naletilić, excuse me. Mr. Krasnik.
May I sit down because I do not feel so well?
Yes, you may be seated. You may be seated.
Sit down, thank you.
Do you hear me?
Donc, Monsieur Naletilić,
Mr. Naletilić, I must warn you and remind you that I've asked you a question that you must answer only by stating that you plead guilty or you do not plead guilty. That's all. And you must answer me now. Answer to count 1 that Madam Registrar has read out. Do you plead guilty or not guilty?
Sir, that is not how I can plead. This is not the way that I can plead.
donc,
So that is, I do not have to. The only thing I have to do is die.
Maître Kursnik,
Mr. Kirsnick, have you explained to your client what a plea of guilt or not guilt is?
Naravno sam.
Of course I did. I'm sorry. Yes, Your Honor, but my client believes that this is also a form in which he can plead. He would like to say that he is not guilty, but he chose to say it in this way.
Maître Kursnik,
Mr. Kirsnick, we're going to take a break, a 15-minute break, and you are going to carefully explain to Mr. Naletilić, because otherwise I cannot continue. A 15-minute break to explain to Mr. Naletilić what his obligations before this tribunal are. We will return in 15 minutes.
All rise, veuillez vous lever.